All right, good morning and welcome. I'm going to call this morning's docket. When I call your name, please say present or here. And I think we have over 50 cases this morning. So council, I want to let you know anyone that doesn't get their business handled before 12 o'clock will be pushed to the afternoon behind the criminal docket and my family law docket. So ask that we move quickly and efficiently. Michelle Daly. Brandon Smith. Cheryl Smith. Michael Welch. Michael Chase Welch. Rebecca Fields. Eric Ketchersid. Billy Schultz. Michael Sprouse or Spruce. Randy Dobbins. Randy Lee Dobbins. Laura Fleming. Jason Nichols. Jason Eric Nichols. Clarence Rowan. Xavier Rojas. Thank you, sir. Kimberly Fowler. Lauren Northcutt. Thank you, Ms. Beasley. Brandy Rhodes. Stephanie Rios. Stephanie Rios. Reginald Young. Thank you, Mr. Kimball. Tanner Sistruck. Here. Thank you, Mr. Harden. Carissa White will be appearing via Zoom, and she is online, along with counsel also appearing online as well. Matthew Kearns. Heaven Weed. Thank you, sir. Veronica Sturgeon. Thanks, sir. Mr. Lacy. Okay, thank you. Did you say Casillas? Yes. Misty Backus. Misty Lynn Backus. Caleb Richardson. Caleb Reed Richardson. Samuel Turner. He say how late?
He said he was about to turn off the meeting about 5 minutes ago.
Thanks, sir. Matthew Grace. Matthew Dale Grace. Ms. Lee, do you have any, you're standing in for Ms. Payne today, is that correct? Do you have any information on Mr. Grace? Okay, thank you. Marcus Gardner. Marcus Dwayne Gardner. Thomas Meek is in Dallas County Jail. Amethyst Wesley. Ryan Hare. Thank you, Mr. Schmidt. James Bustamante. Joshua Hand. Leonard Purley. Avery Plunkett. Verified Dallas County Jail. Bobby Richards. Amy Harmon. Thank you, Mr. Stevens. William Robertson. Ronald Toll. Thanks, sir. Christopher Lipoma. Mitchell Ragland. And then we have a few at 10 and one at 11. I'll just go ahead and note for the record that Mario Gutierrez is present with Mr. McHaslett. Is Clarissa McMillan here? Okay, she's not scheduled for 10. Keith Thomas, scheduled at 11. Is there anyone who's present in the courtroom whose name I have not called? All right, counsel, if anyone is ready, if we'll form a line right over here so I know how to call you, then we'll be ready to go. Mr. Casillas? Yes, please.
Finally got the PPD this morning.
Here, I'll tell you, you keep that and you'll fill that out. And thank you.
Access to the portal.
Give me a second. I'll call the case and I'll let you make that announcement. This is cause number CR 20248, State versus Veronica Anastasia Sturgeon, set for pretrial. Go ahead. Where's Miss Sturgeon at? Okay, I'll let her get up here to the podium. All right, go ahead, Mr. Casillas.
Yes, Your Honor, we did receive the PPD disc this morning from the DA's office. We are having issues getting access to the portal.
Judge, it's my understanding that the issue with the portal has been resolved. We've asked the defense check that and inform us if it's not, but otherwise it's the way it should be working. Fine. State does not oppose the recess.
Just one second. We need to see if Peggy has the cheat sheet for me on scheduling. She usually gives me like what's set in the future. I don't have that, so I don't overload the docket either. All right, Mr. Casillas, then the court will reset Miss Sturgeon for an additional. We'll reset Miss Sturgeon then for pretrial on November 30th. You have any scheduling issues that day, Mr. Casillas?
Should not, Your Honor, but also be a 9 a.m. docket.
That'll be a 9 a.m. docket as long as your client's on bail. It'd be 9 a.m. If she's ever in jail, it'd be at 1:30. So what I would ask you to do is either you or your office check on the access to the portal before you leave. And if we're still having issues, I'm going to ask that you get with the state today rather than leaving and then coming back on the 30th and then having that issue. So check today and let them know if it's working great. If not, then we need to get that resolved today. And so Ms. Sturgeon will sign that notice of setting and you'll give her the yellow copy. The white copy will stay here. And then she'll sign it and then she'll be free to go.
Thank you.
Ryan Harry, Your Honor.
Ryan Hare, CR 21-218. Mr. Hare is set for pretrial.
Yes, sir. We have no. We have all.
Mr. Schmidt, would you be opposed to a November 9th setting? That's only a few weeks, but do you think that's enough time for you and the state to decide whether or not the case can be negotiated?
Mr. provided some information.
All right, December 14th.
December 4th.
Yeah, that's the next available.
I can do that November 30th. That's too full.
Yeah, we're already at 70 cases that day. So it's either going to be November 9th or the 14th.
Sure, I don't see why not.
All right, December 14th, Mr. Hare, for docket call. And once you sign and get the yellow copy, you'll be free to go.
Thank Thanks, Judge. What's the time for that meeting?
Yes. Xavier Rojas, CR 21-238. And also CR 21-256. Now, the court did grant the motion for continuance for today's hearing, and I just ordered him to appear to sign the notice of setting and to check in with pretrial release. So do you want to make an announcement while you're here? You just- Okay. All right, so the court's already ruled on the defendant's motion for continuance, and that date's going to be in that order. I can't recall what that is. So I think it's November 30th, which is going to be the last settings on the 30th. So once he signs that, then he'll be free to go, but he does need to check in with pretrial release. Before he leaves. Matthew Kearns, CR 2199. All right, Mr. Kearns is set for pretrial, Mr. Hyde.
Yeah, we've got everything. It's very standard. We need more time. This involves making records and bankruptcy. We're working through it. We just need more time.
All right, December 14th. All right, Mr. Kearns, you're ordered back for docket call on December 14th at 9 a.m. Once you get the notice of setting and sign it and get the yellow copy, you're free to go. Tanner Sistruck, CR 21-189. Mr. Sistruck is set for pretrial.
Yes, Your Honor, I asked that recess one time because I received paper discovery this morning by going back, I'm filling it, online. Look at it and see what there is.
Any announcement from the state on, is there still an issue with the portal or?
There's some issue, we're not sure. We're trying to work with LGS and Mr. Harmon on this. But we did, because of the issue, we did bring out all the paper discovery. It's not our normal policy, just so we can have it. We would obviously be able to vote for one more reset and see if this all the reports. Leading up to the last time with these discovery is fine. This case, but if we have booster cases, obviously we will need to continue work on
All right, court will set Mr. Sistruck then for an additional pretrial on December 14th at 9 a.m. And once you sign the notice and get the yellow copy, you're free to go, sir.
Yes, sir.
Reginald Young, CR 2198. You can just leave it right there.
We have no protection for pretrial matters.
All right, there being no contested pretrial motions, the court will set Mr. Young for a docket call on December 14th, unless you have any scheduling issues, Mr. Gimbel.
I'm sorry,
Do you have any scheduling issues on the 14th?
the 14th works fine.
Mitchell Ragland, CR 21-185.
Legal reception free holiday.
Correct.
Soon we're still operating under court standing order. I believe we received everything from the state. We won't be filing any test motions at this time. That's what we'll.
You available on December, we can do November 9th or we can do December 14th. Depends how much time you want. All right, court sets Mr. Ragland then for docket call on December 14th at 9 a.m. Once you sign and get the yellow copy, you're free to go, sir. Thank you, Mr. White. You have a better day. I think you're going to. Who do you want to call first, Ms. Beasley? Lauren Northcutt, CR 21-232. Okay, thanks. All right, Ms. Northcutt, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Aaron? Is our amplifier on, the microphones? Do you know if we need to? 'Cause I can't really hear them. I think when we were messing with the. Thank you. All right, Ms. Northcutt, is your name Lauren Francis Northcutt?
Yes, sir.
And Ms. Northcutt, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with? Okay. Are you currently on medication or undergoing treatment for that?
Yes, sir.
Do you feel like today that you have rational thought and understanding of what's going on?
Yes, sir.
In this case, you're represented by your attorney, Ms. Deborah Beasley. Are you pleased with her representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with her and have all your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
Yes, sir.
Ms. Beasley, do you believe your client to be competent today?
Most definitely.
And have you explained to her her legal rights and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir. I'll
And do you believe she understands those?
definitely.
I see here that the proposed plea agreement is that Ms. Northcutt will plead guilty to a third-degree felony offense of assault of a family or household member with a previous conviction in exchange for the state's recommendation that a finding of guilt be deferred, with her being placed on 4 years community supervision plus fine, court costs, reimbursement fees, and that she will have to complete anger management and a cognitive behavioral condition evaluation as a condition of her probation or community supervision. Is that your understanding, Ms. Northcutt, of the agreement?
Yes, sir.
And that's what you want the court to approve today?
Yes, sir.
Ms. Northcutt, a third-degree felony has a range of punishment of not less than 2 years or more than 10 years confinement in a Texas prison and a fine not to exceed $10,000. Do you understand that if the court approves the agreement today and I place you on deferred community supervision, if subsequently you violate that community supervision and the state brings you back to court, they file a motion and they present evidence and they prove to me that you violated a term of your community supervision, I could adjudicate your guilt. That means I could find you guilty of this offense, that I could revoke your community supervision, and that I could sentence you to a prison sentence anywhere between 2 years up to 10 years. You understand that?
Yes, sir.
Understanding the range of punishment in the plea agreement, then you want to go forward still?
Yes, sir.
How do you plead then to assault of a family or household member with a previous conviction?
I'll be guilty.
Are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? All right, the court accepts the defendant's plea of guilt. Ms. Beasley, any objection to State's Exhibit 1? All right, State's Exhibit 1, the stipulation of evidence is admitted. The court does take judicial notice of the defendant's judicial confession. Anything further from the state? Thank you, Ms. Heisel. Anything further from the defense? All right, the court's reviewed the evidence. I do find enough evidence to convict Ms. Northcutt of this offense. The court will follow the plea agreement in this case. Court defers a finding of guilt, places Ms. Northcutt on deferred community supervision for 4 years, orders her to pay a $2,500 fine, $785 reimbursement fees, $290 court costs. Court orders her to successfully complete an anger management and cognitive behavioral condition evaluation as a condition of her community supervision. Because I noticed that I'm gonna sign my portion. I'm gonna return these to you to have the dates acknowledged. A lot of these say October 27th. No, it's pre-printed. It's pre-printed. So I'm just gonna have y'all mark an initial. The judgment's correct. So, well, the front page of the judgment's correct. I got the back page, but there's a couple in the admonishments. If we can I just want those initialed by you and your client. If you want to, you can bring her forward. And Ms. Northcutt, if you'll come forward, we're gonna have you fingerprinted and make some changes. Ms. Rhodes, if you'll come forward, CR 19-280. All right, this is cause number CR 19-280, State of Texas versus Brandy Rhodes. Understand that the state has filed a motion to adjudicate. Today, the state has submitted a motion to withdraw the state's motion to adjudicate. And it appears that there's an agreement to resolve this matter with Ms. Rhodes agreeing to extend her community supervision for 2 years and accepts new conditions requiring her to pay the attorney fees for today in addition to court costs. Ms. Rhodes, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. So Ms. Rhodes, you are asking the court to extend your probation period for an additional 2 years, which would extend your community supervision period all the way out to November 19th of 2026. Is that correct? And you understand that by extending your probationary period, not only will you have to report longer, but you'll also have additional costs, court costs, reporting fees, and you're also going to have to pay for your attorney fees that have been incurred in this case for this motion to revoke or motion to adjudicate. You understand that? Has anyone threatened, forced, or pressured you to make you feel like you had to do this today? You're asking the court to extend your community supervision for those 2 years? Do you believe that if I do that, do you believe that you will successfully complete your community supervision? All right, the court grants the state's motion to withdraw the motion to adjudicate. Court hereby extends Ms. Rhodes' community supervision, finds that she has entered into this agreement intentionally, knowingly, and voluntarily. All right, Ms. Rhodes, if you'll come over here and report to the probation department, they'll get you some paperwork and be free to go. All right, you ready on Ms. Fowler or Kimberly Fowler, CR 19-214? All right, Ms. Fowler is set on the motion to adjudicate today.
That is correct, Judge. If I may, I'm in negotiations with Ms. Curry. We have reached an agreement, however, it involves prison time. I would ask the court to please set this for the first day available for plea after Christmas, so that she can spend the time with her family. She is meeting with probation. She passed the UA test and she's doing really well. And she understands that if the court were to consider allowing her to finish the holidays with her family, that she would have to continue obeying all of the rules of probation.
Mr. Woodward.
I'm sorry, without a custody, it's not costing the county money, so do what the court wants to do.
Judge, this is Mr. Curry's case, is my understanding. It's easily for this arrangement, so the state is opposed to saying that as long as Fowler is meeting all of her conditions of probation, continues to do so. If not, then we'll bring after Christmas, and then we will resolve this case prior.
That's correct. And I also explained to her before and also today that if for any reason that she would have failed the UA test, that the court's discretion can put her legally back into jail.
And you said that she's passed her UA test. Did she take one today, or she just, you talking about her last one?
In the past, since she had the motion revoked, she's taken them, but she could take one today.
Yeah, let's go ahead and do that. We'll, the court will drug test Ms. Fowler, and if she passes the drug test, then I'll approve the agreement to reset until after Christmas. So Ms. Fowler, just come over and have a seat.
If I make an announcement on the Rios for the court.
Go ahead.
She's running a little bit late, but she will be here. On her way.
Okay. You said who, Mr. Landfrey?
Brandy Rhodes.
How do I have Mr. Landry on my docket?
I'll check that in my office, I'll check,
Tell you what, let me look in the system. Might be quicker for you. We check on Randy Landfree, LANFREY, CR 21249 in the system. I can see that he had arraignment on September 16th, but I don't show a notice of appearance. I don't show us. Ms. Beasley has it set for today, but it's not on our docket. It's not scheduled in our dockets, and there's no notice of appearance for September. Thanks. All right, I'll work on that. Okay, she's going to look at Mr. Landry. I don't even show our notice of setting from the last time he was here in September. Yeah, which is why I didn't get on the dock. It's not scheduled either, so we'll check on that. Mr. Manning or Mr. White, you ready? Christopher Lipoma. This is CR 2125 set for motion to adjudicate.
That's correct, Your Honor. And these, I believe that there is a civil, sports. I received the Dobbins on Friday afternoon. I still don't have CDD. This does not get negotiated. It can be in effect.
All right, the court will set Mr. Lipoma then on the court's contested docket on December 2nd.
We just setting it for the second.
We're setting for a contested hearing on the second on his I'm not setting the misdemeanor because it's not in my court. I'm setting the motion to adjudicate on the contested docket on December 2nd.
They can be prepared. If not, they can be prepared to proceed on the motion. Sorry.
It's okay. So Mr. Lipoma, you ordered back on December 2nd. Once you sign and get your yellow copy, you're free to go. Make sure you're still reporting to your probation department. Just talking to her about that. It's Debbie's client. Welch. So he's here. Thank you, Mr. White. So he is here. Is Misty Backus here? Come on to the middle podium. This is CR 21-158. State versus Misty Lynn Backus. Go ahead, Mr. Manning.
Yes, Judge. Ms. Bachman has decided to accept the offer that was made for her today. We request it be set, I believe it's set November 9th. Is that coming up?
I do have availability on November 9th.
If we have it set the 9th, that'd be great.
All right, court sets Ms. Backus for plea on November 9th at 9 a.m. Mr. Manning, I do show that your client is delinquent on her pretrial release. I don't know if the plea is for time or for probation. If it's for probation, then I'd like that to be considered in the probation conditions
Okay. I will-
or delinquencies.
I know that she's just coming off being ill with COVID, so I'm sure that she's trying to. We align with all people.
Have her, Ms. Backus, after you sign, go ahead and report over here to Mr. Waddell, at probation department. Well, I think his is at 10 o'clock. Mr. McCaslett, you just have the one today, correct?
Yes.
Okay. Mr. Schmidt, are you ready?
Yes, sir.
James Bustamante, CR 21-9, CR 21-281. All right, Mr. Bustamante is set for docket call today and pretrial on 281. All right, court will set Mr. Bustamante for docket call on December 14th. Can you do November 9th? No, that's a Thursday. November 9th will be Tuesday. That's 2 weeks. I got that. Let's see, I got November 9th. 30th is full. Second is December 2nd is an evidentiary day. So yeah, I'm kind of stuck right now with November 9th or December 14th. Okay. All right, court sets Mr. Bustamante then for docket call on November 9th.
Amended condition pretrial release on Monday, we asked.
I believe this is at one location to the, do not go to no contact provision.
All right, Mr. Bustamante, once you get your yellow copy, then come back here and meet with pretrial release to sign some paperwork, and then you'll be free to go. Joshua Hand, CR 21-168. Mr. Hand is set for pretrial today. All right, court will set Mr. Hand then for docket call on November 9th at 9 a.m. And once he gets his yellow copy, he's free to go. Leonard Purley, CR 21-234. Mr. Purley is also set for pretrial. Court sets Mr. Purley for an additional pretrial on November 9th at 9 a.m. Once he gets the yellow copy, he's free to go. Mr. Richards. Bobby Joe Richards, CR 2134. All right, Mr. Richards, if you'll raise your right hand, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, Mr. Richards, you may put your hand down. Mr. Richards, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? Here, do me a favor. You can move that microphone back down so it doesn't fall off. And Mr. Richards, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with your with his representation of you in this case? You feel like you've had enough time to go over all of the documents in this case and your case and have all your legal questions answered? Everything's fine? You feel like you understood everything that you read and signed today in court? Mr. Schmidt, do you believe Mr. Richards to be competent today? And you've explained to him his legal rights and also the advantages and disadvantages of a deferred adjudication plea? And you believe he understands those? Mr. Richards, you are charged by indictment with a state jail felony offense of abandoning or endangering a child with criminal negligence. If convicted and sentenced in that case, you could be sentenced to a term of imprisonment anywhere between 6 months up to a maximum 2 years in a state jail prison, and also fined up to $10,000. You understand that full range of punishment? And I see here that the agreement in this case is that you would plead guilty to that charge in exchange for the state's recommendation that a finding of guilt be deferred and you be placed on 3 years community supervision with a fine, court costs, and reimbursement fees. Is that your understanding of the plea agreement? And so, Mr. Richards, if I approve the plea agreement today and you go on community supervision, if at a later time you violate and the state files a motion to adjudicate, and they bring you back to the court and they produce evidence that proves that you violated, the court at that time could find you guilty of this offense. The court could revoke your community supervision, and the court could sentence you anywhere between 6 months up to 2 years in prison. You understand that? Understanding the full range of punishment and the plea agreement in this case, do you want to proceed? All right, then, Mr. Richards, how do you plead to abandoning or endangering a child with criminal negligence? And are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? All right, the court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to State's Exhibit 1? State's Exhibit 1, the stipulation of evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Out of this, Mr. Richards said extremely well, completed all of his services. I believe that his return last week and is made from the practice of state offer.
That's good news, Mr. Richards. All right, the court's reviewed the evidence. I do find enough evidence to convict Mr. Richards. However, the court will follow the plea agreement in this case. The court defers a finding of guilt, places Mr. Richards on 3 years community supervision, orders him to pay a $2,000 fine, $590 court costs, $590 reimbursement fees, $290 court costs. All right, Mr. Richards, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward with the bailiff here to be fingerprinted. After that time, report to Officer Mature here and she'll give you further instructions. We need to do Avery Plunkett, just to get an announcement on that. CR 21-268-269, State versus Avery, Darian Plunkett, set for arraignment, show that he is still verified in custody in Dallas County. Court will reset Mr. Plunkett for another arraignment and status on his Dallas County incarceration. And I will set that. You have any scheduling issues on January 6th? All right, Ms. Lee, are you ready?
Yeah.
Matthew Grace, CR 21-67. All right, Mr. Grace, Ms. Shunda Lee, an attorney here, a licensed attorney here in the state of Texas, is standing in for your attorney of record, Miss Amanda Payne. Do you know Miss Lee? Okay. All right. And I showed that Mr. Grace is set for docket call today. Do you have any announcement on his behalf? Mr. Woodwike, I know you're busy, but Miss Lee wants to approach the bench on Mr. Grace. All right, Mr. Grace, I understand that your attorney, Ms. Payne, is unavailable today. And it seems to me, based on knowledge that she has given to me that, and also to the attorneys for the state, and Ms. Lee has reported it to me as well, that she is not going to be back and available until March of next year. So I don't know if you've had that conversation with her. Okay, I didn't think you had. So this is what we're going to do, okay? I'm going to reset your case for another setting, and I'm going to reset it until December 14th. And that'll be at 9 o'clock. And this is what I recommend that you do, that you speak with your attorney, Ms. Payne, and you can let her know that I've not agreed to reset your case until she gets back until next year. And so my recommendation is that you speak to her about that and determine whether or not you're going to continue her as your attorney. You may need to seek counsel to represent you other than Ms. Payne, because the court's not going to reset your case because she's unavailable. And I believe that she's out of the country at this time.
Really?
Yes. So I want you to contact her and have that discussion with her. And then on December 14th, you may very well need to come back and have different counsel. So I understand the situation. Well, and I'm going to invite you to speak with Ms. Lee. She may be able to address some of these other issues for you, but I understand the situation you're in. And so I'm just going to give you some more time and reset you a little bit longer, and then let you try to get the business that you have is business between you and Ms. Payne. So I need y'all to address that. And then you come back on the 14th, and then we'll have our discussion after that. Okay. All right. So I'm going to have you sign a notice of setting. Ms. Lee has that. After that, come back here and meet with Mr. Waddell with pretrial release. And then you and Ms. Lee can go outside and have a conversation. Okay. All right. Thank you, Ms. Lee. All right, I'm going to have to bring in Mr. McHaslett at this time. I have an interpreter scheduled for 10 o'clock for his client. All right, this is cause number CR 21-119, State versus Mario Alberto Gutierrez. Yes, that's fine. Sure, yeah, absolutely. Okay, Mr. Perales, I'm going to swear you in at this time. If you will go ahead and state your name and license number for the court, and then I'll administer your oath. All right, Mr. Perales, if you'll raise your right hand. Sir, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given to the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right, thank you, sir. All right, Mr. McHaslett, Mr. Gutierrez is set for docket call today. Have you and the state reached any final agreement with your negotiations, or is Mr. Gutierrez ready to make that announcement, or?
Yes, Your Honor. We're ready to reach an agreement, and our intentions will be getting.
Okay, and are we prepared to do that today, or are we asking the court to set it for a plea?
In this regard, we have to.
Okay. All right, Mr. Gutierrez, I'm going to ask you to put the phone in your left hand and raise your right hand. Mr. Gutierrez, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. Is your name Mario Alberto Gutierrez? Mr. Gutierrez, are you a United States citizen? Mr. Gutierrez, do you understand that any plea of guilty before this court today and any adjudication of your guilt for any offense may affect your legal status in this country? And do you understand that it also may, not only may it affect your legal status in the country, it may also affect your ability to re-enter the country if deported? And have you spoken to your attorney, Mr. McHaslett, about this, or any other attorney about your immigration status? And understanding the possible consequences of a plea of guilt today, do you still wish to go forward in this case? Have you ever been diagnosed with any type of mental condition? And in this case, you're represented by your attorney, Mr. Servando McHaslett. Is that correct? And are you pleased with his representation of you? And do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered? And Mr. McHaslett also speaks Spanish, doesn't he? And did Mr. McHaslett explain to you the paperwork in the Spanish language as well as the English language? All right, and Mr. McHaslett, do you believe that Mr. Gutierrez is competent today?
I do, Your Honor.
And have you advised him, or has any other attorney advised him regarding the immigration laws and how they may apply to his case if he is convicted in this court today?
I have, Your Honor.
And you believe that he understands the risk associated therein?
I do, Your Honor.
All right, I see the plea agreement in this case is that Mr. Gutierrez would plead guilty to driving while intoxicated with a child under 15 years of age, that the charge would be reduced to a Class A misdemeanor under Section 1244B. Is it a 1244A or B? Because it says B, but then it says state jail felony.
It's B, it's a misdemeanor conviction and misdemeanor punishment.
It says state jail felony on here. Now, it says degree of offense is misdemeanor A, but then it says 1244B SJF. You want me to just strike through SJF or state jail felony?
However, the court is comfortable with, yes, Judge. We intend to proceed under a Class A misdemeanor. The offense is still driving intoxicated with a child passenger, but if we are punishing, we're convicting and punishing as a Class A.
All right, so the court's going to mark through the SJF, which I believe stands for state jail felony. And in the agreement, Mr. Gutierrez, the state would be recommending that you, upon your plea of guilty to that charge, that you be punished with 7 days confinement in the Van Zandt County Jail, with you receiving credit for 1 day of service and you serving the additional 6 days at a later time as laid out in Exhibit A, which would mean that you would be going to jail and serving the remainder of your sentence on the weekends on Friday, November 5th, being released on Sunday, November 7th, and then again going to jail on November 12th, Friday, November 12th, and being released on Sunday, November 14th. In addition to the jail time, you would have to pay a $1,000 fine, $35 reimbursement fees, and court costs in the amount of $270. Is that your understanding of the plea agreement? All right, Mr. Gutierrez, then how do you plead to driving while intoxicated with a child under 15 years of age, a Class A misdemeanor with a maximum jail time of up to 365 days in jail and a $4,000 fine? That's the range of punishment. How do you plead to that offense? Does he plead guilty or not guilty? And Mr. Gutierrez, are you pleading guilty because you are guilty of committing that crime? Has anyone threatened or forced or pressured you to plead guilty today? All right, the court will accept the defendant's plea of guilt. Mr. McCaslett, any objection to the evidence that states one?
No objection.
All right, states one is admitted and the court takes judicial notice of Mr. Gutierrez's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, the court's going to review the evidence briefly. All right, the court has reviewed the evidence and the court will follow the plea agreement in this case. The court convicts Mr. Gutierrez of driving while intoxicated with a child under 15 years of age. Court assesses punishment under section 1244B. Court sentences Mr. Gutierrez to 7 days confinement in the county jail. Court awards him credit for 1 day served. Court orders him to serve his remaining sentence on the dates and times indicated in Exhibit A of the special order for committing to jail. The court also orders Mr. Gutierrez to pay a $1,000 fine, $270 court cost, and $35 reimbursement fees. Mr. McCaslett, do you know if Mr. Gutierrez is able to take care of his fines and fees today?
He is not,
Okay, so you've already taken him down there and introduced him to Ms. LaPrade and what he needs to do,
yes,
and you believe he understands that?
yes,
Okay, thank you for doing that. All right, Mr. Gutierrez, it's very important when you go to serve your remaining days in jail that you must take two things with you. You must take a picture ID and you must take this order this judgment in order showing that I'm ordering you to go and serve your additional jail time. If you don't bring an ID so they can identify that you are Mario Alberto Gutierrez and you don't bring this order, they're not going to let you in the jail. And if they don't let you in the jail, then they're going to let me know that they're going to tell me that you showed up without doing what I told you to do. And I'm going to have to bring you back to court. You understand? And Mr. Gutierrez, do you have any questions about any of the things we've done today? All right, Mr. Gutierrez, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step forward with my bailiff here to be fingerprinted. After that time, accompany Mr. McCaslett and go down and meet with the court compliance officer. Thank you, Mr. McCaslett. Thank you, Mr. Perales. You as well. I can't hear you. Okay. Evan Weed, CR 21197. All right, Mr. King, I'm going to ask that, so she needs to be sworn by the clerk on these two documents. And so if you'll just step into the clerk's office, they can swear her on the stipulation of evidence and also the waiver of speedy trial and limited waiver of expunction. And then I'll work you right back in, okay? She'll just need to be sworn on those. So if you'll just give it to the clerks, they'll walk her through that. Yeah, go through this door over here and then come around and then she'll be right here in this office, right behind this one.
Okay.
You may. Mr. Murray Leader, are you ready? Samuel Turner, CR 21-147. You may. All right, Mr. Turner is set for docket call today. Mr. Murder Leader has tendered to the court a waiver of jury trial. Mr. Turner, I have to ask you a few questions about this. You'll raise your right hand, sir. I'm going to place you under oath. Mr. Turner, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. So, Mr. Turner, I hold in my hand a document entitled Waiver of Jury Trial. Have you discussed this with your attorney, Mr. Murder Leader? And do you believe you understand it? You understand that as you stand at that podium today, you have the absolute right to a trial by a jury of your peers on the accusation from the state of Texas. Do you understand that? And you understand that if you invoke that right, that this court would select, I would call and summons people, and we would come to the courtroom, and you, through your attorney, and the state through their attorney, would have the opportunity to select a jury, and that jury would be impaneled, and that jury would be called upon to determine whether you were guilty or not guilty on the accusations of the state. And during that process, not only would the state, but your attorney would also have the right to confront the state's witnesses, to cross-examine them, and put on any witnesses or evidence that you chose to put on in front of that jury. Do you understand that? You understand that by waiving that whole process, waiving the whole right to a trial by jury, you would also be giving up that right to bring witnesses or cross-examine and confront the state's witnesses and evidence before a jury. You understand that? If you waive your right to a jury trial, then the court would then decide whether, if you did not have a plea agreement, the court would then decide whether you were guilty or not guilty. You understand that? And you understand that once you waive your right to a jury trial, there's very limited circumstances in which that could be restored to you. Okay, so understanding all of those things, and you've discussed that with your attorney, is it your intention to waive your right to a jury trial? And has anyone threatened, forced, or pressured you to do that? All right, Mr. Murray Leader, I believe that you're asking the court to allow Mr. Turner to plead guilty openly to the court, and for the court then to decide whether the court is to accept that plea of guilt, and also then to decide what punishment, if any, is applied to Mr. Turner.
That's correct, Your Honor. And it's charged on the date of the third. The state is abandoning one enhancement paragraph in order for us to plead open to the court. In a 220 case, Mr. Turner is requesting probation for him. I believe for our side, Judge, it'll probably take a couple of hours. We ask the court to reset this for a contested knowledge.
All right, and you believe that Mr. Turner has intentionally, knowingly, and voluntarily waived his right to a jury trial, and you join him in this decision?
That's right.
Court will also note for the record that the state of Texas has also waived their right to a jury trial along with Mr. Turner. So, Mr. Turner, the court will find that you have intentionally, knowingly, and voluntarily waived your right to a jury trial, and the court will allow you to continue in this case with an open plea before the court. The court will set Mr. Turner's open plea on December 2nd at 9 a.m.
Judge, we're requesting a PSI.
Okay, court will order the Van Zandt County Community Supervision and Corrections Department to prepare a pre-sentence investigation report and to return that to the court and to counsel at least 5 days prior to the hearing on December 2nd.
Judge, I have a few exhibits for PSI. I'll drop that out with Mr. Turner.
All right, and once Mr. Turner signs his yellow and gets his yellow copy, he's free to go. And so, Mr. Turner, you will be contacted by the Van Zandt County Probation Department, and they'll need to set up a time to talk with you about the case and to get information regarding your background, family history, employment, substance abuse, things of that nature. And that's all part of this report that they're going to tender to me so that I can use it in determining after you plead guilty, what type of sentence would be appropriate in this case. Okay. So I'm going to expect you to fully comply with them in their discussion with you about the case. Okay. You're welcome, sir. All right. You're free to go. Yes, please. All right, thank you for doing that. All right, Ms. Weed. All right, Ms. Weed, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. Your name is Heaven Leanne Weed, is that correct? Did I pronounce it correctly? Is your middle name? Okay. And Ms. Weed, you have been charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 2, greater than or equal to 4 grams, but less than 400 grams. That does carry a range of punishment if convicted and sentenced somewhere between a minimum of 2 years and a maximum of 20 years confinement in a Texas prison and a fine not to exceed $10,000. Do you understand that full range of punishment? Now I see here that you are represented by your attorney, Mr. Jeffrey King. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him, have all your legal questions answered? Is there anything about this paperwork today that you've read and signed that you do not understand? Okay, and are you a United States citizen? And do you read, write, and speak English? I don't know if I've asked you, have you ever been diagnosed with any type of mental condition? How long ago was that? 17, so about 4 years ago. Are you currently on any type of medication or undergoing treatment for that? And do you believe those medications are helping you have rational thought and understanding of today's proceedings? You know what's going on in the case today? Okay, thank you. All right, and Mr. King, do you believe that your client is competent today to enter into an agreement?
Yes, Your Honor.
And you've explained to her the advantages and disadvantages of all of the terms and conditions of the pretrial intervention contract? And you believe her to understand all of those?
Yes.
So, Ms. Weed, I see that you want to enter into a pretrial intervention contract with the state of Texas. And I want you to know that as part of this, you're going to be giving up some very important rights. One of those is the right to a jury trial in your case. Do you understand that by waiving your right to a jury trial, you're waiving your right to have a jury to hear the case and decide whether you're guilty or not guilty? You understand that? And you understand that once you agree to waive your jury trial, it's not going to be restored to you. You understand that? There's really limited circumstances once someone waives their right to a jury trial that it can be given back to them. You understand that? And so what that means for you is if I approve this agreement today and you go into this contract, and if there are problems, if you violate any of the terms and conditions of your contract and the state wants to come back to court and wants to put you to trial, at that time, you can't say, Judge, I want a jury trial. You will have given up that right. You understand that? And you discussed this with your attorney, Mr. King, right? And so are you intentionally, knowingly, and voluntarily giving up your right to a jury trial? In addition, you would also be giving up your right to the expunction of your criminal records with regards to the Van Zandt County DA's records and the probation office records. If you successfully complete this program, then you may petition the court to clear your records, your criminal record, with regards to the arresting agency, the Texas Department of Public Safety, several agencies that collect criminal records. You'll be able to expunge those, have those cleared. However, you will not be able to have the Van Zandt County DA's office records cleared, and you will also not be able to have the probation office records cleared. Do you understand that? All right, I see that the agreement with Ms. Weed and the state is that she would enter into a pretrial intervention contract for a period of 2 years on the charge of possession of controlled substance, penalty group 2, greater than or equal to 4 grams, but less than 400 grams. Ms. Weed, you also are agreeing that certain evidence will become admissible if we have to have a later hearing about your case. You understand that? All right, so understanding all the things we've discussed today, you still want to go forward with this pretrial intervention contract? All right, the court's going to find that Ms. Weed has intentionally, knowingly, voluntarily waived her right to a jury trial after being admonished, and that she's also waived her right of a speedy trial and a limited waiver of expunction after being admonished. The court will hereby approve the placement of Ms. Weed into the pretrial intervention program for a period of 2 years and order her to comply with all terms and conditions of the agreement. All right, Ms. Weed, I'm going to have you report to the Van Zandt County Probation Department here with Officer Matura, and she'll give you further instructions. Thank you, Mr. King. Yes, thanks, sir. Mr. Stevens, are you ready?
Yes.
Hang on, let's get her up here real quick. Let me call it and get it on the record, and then we'll call her up here. All right, this is cause number CR 21-121, State versus Amy Beatrice Harmon, set for plea. Go ahead, Mr. Stevens.
It wasn't for plea, when my clients asking for a jury trial.
Okay, what was the plea agreement that she was set to enter today?
18 months at jail, probated for 2 years.
18 months probated for 2.
Yes, for 2 years. 45, 35.
All right, and so Ms. Harmon, do you understand that by rejecting the state's plea agreement today, then the court would set you for a jury trial in this case, and that you're not going to be allowed to enter into a plea agreement with the state after today? That means if we get to the Friday before jury selection and you decide that you want probation because you're concerned that you may end up going to prison, the court's not going to allow you to enter into a plea agreement? And so you've taken your time to discuss that with Mr. Stevens? And you understand that if convicted of this offense, if you're sentenced by either the court or by the jury, that the range of punishment is a minimum of 6 months to a maximum of 2 years in a state jail prison where there is no parole. You understand? That's fine. That's fine. I'm making sure that you understand what the potential risks are if you go to trial. All right. All right. The court will set Ms. Harmon then for jury selection beginning December beginning December 6th. So Ms. Harmon, on December 6th, you will report to the basement of the courthouse. You will not report to the courtroom. We'll be selecting a jury that day. Your case will not be selected on that day. However, you're required to report. My staff will be in the basement and they will give you the next setting. You'll sign that. Mr. Stevens is not going to be required to be here until your case is reached for trial, and you'll come up here every month until your case is reached for trial. Okay? So that'll be at 8:30 in the basement of the courthouse. And I want you to continue to report to your pretrial release officer. All right, you ready on Mr. Robertson? William Robertson, CR 21, 142 and 151. Yes. All right, Mr. Robertson, you're set for docket call on December 14th. Mr. Stevens has asked for additional settings so he can continue to negotiate with the state. So I'm gonna have you come back on December 14th at 9 a.m. Once you sign this notice and get the yellow copy, you're free to go. Brandon Smith. Brandon Smith, CR 14, 193. All right, Mr. Smith is set on the motion to revoke.
Yes, sir. We have reached an agreement, Your Honor. We don't have a meeting to study today, so we're canceling. It will not require me to.
What's the offer and what's the agreement?
Well, I'm not sure. Basically, some of the time, sir, I'm not exactly sure how to frame the offer.
Judge, we need to look at the details, like, we've reached an agreement in general, we need to look at the exact details, Mr. Stevens and I worked that out prior to.
Do you think a couple of weeks will be fine? Is it just an issue of paperwork?
Basically, we gotta get together with Steve. Would it be possible to set it on that December 14th back up since I'm going to be here? Is that possible?
If we need that long.
Mr. Stevens, of course, would be, if we can get it done.
I think you mentioned something.
That's, we'll do the 14th. Court sets Mr. Smith for motion to revoke on December 14th at 9 a.m. Mr. Smith, you're still on probation, so you still got to report and comply. You ready on Ronald Toll?
It's all right.
Ronald Toll, CR 21-146. Thank you, sir. All right, Mr. Toll, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Your name is Ronald Darren Toll, is that right? And Mr. Toll, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? What is that? Okay, are you on medication for those three different things? And do you believe those medications are helping you have a rational understanding today so that you can understand what's going on in court?
Yes.
Okay. And in this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss the case with him and have all your legal questions answered? Is there anything about this paperwork that you've read and signed today that you do not understand? Mr. Stevens, do you believe Mr. Toll to be competent today?
Yes, sir.
And you've explained to him his legal rights and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir, I did.
Do you believe he understands all of those?
Yes, sir, I did.
Mr. Toll, you're charged by indictment with a state jail felony offense of criminal mischief greater than or equal to $2,500, but less than $30,000. That carries a range of punishment of not less than 6 months or more than 2 years confinement in a state jail prison and a fine not to exceed $10,000. I see the plea agreement in this case is that you would plead guilty to that charge, and the state would recommend to the court that the court defers a finding of guilt. That means that the court not convict you today, and that you be placed on 4 years community supervision, that you be ordered to pay restitution in the amount of $8,633.99, plus court costs and reimbursement fees. And the state would also dismiss a couple of other cases of criminal trespass. Is that your understanding of the plea agreement? And you understand that if the court approves this today and later you violate the terms and conditions of the probation, if the court conducts a hearing and finds that the evidence is sufficient to prove that you violated your probation, the court could find you guilty, the court could revoke you off of community supervision, and the court could send you to prison anywhere between 6 months and 2 years to a state jail division prison with no parole. You understand that? Understanding those things, you still want to go forward? All right, then I'll ask you at this time, Mr. Toll, how do you plead to criminal mischief greater than or equal to $2,500 but less than $30,000? Guilty or not guilty? Okay. Court, and Mr. Toll, has anyone threatened, forced, or pressured you to plead guilty today? And are you only pleading guilty because you are guilty of committing that crime? All right, court accepts the defendant's plea of guilt. Mr. Stevens, any objection to the state's one evidence?
No, objection, Your Honor.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we have resting clause.
from the defense?
Resting close, Your Honor.
We'll take a brief moment to look at the evidence. All right, the court finds that there's enough evidence to convict Mr. Toll. The court will follow the plea agreement. Court will defer a finding of guilt, place Mr. Toll on 4 years deferred community supervision, orders him to pay orders him to pay a zero fine, restitution in the amount of $8,633.99, orders him to pay $290 court costs and $835 reimbursement fees. Court takes into consideration DA 2021-282 and DA 2021-281. Mr. Toll, you hereby remanded to the custody of the Van Zandt County Probation Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward here with the bailiff to be fingerprinted.
Thank you for this morning. I'll be excused till this
Yes,
afternoon.
absolutely. Thank you, sir. Mr. Woodwhite, can I see? Hey, I'm just. Mr. Russell, are you ready? Marcus Gardner, CR 2161 and 162. All right, Mr. Gardner, set for docket call.
Yes, sir. We're requesting to set for plea on November 9th at 1:30.
Judge, I'll remind the court that we already have a waiver jury trial in this today with the paperwork done. However, Mr. Gardner is requesting an additional 2 weeks before he can consult anyways. So we're just gonna ask for that November 9th setting for him to be at the jail. So he's both currently.
All right, court will set Mr. Gardner then for plea on November 9th at 1:30. Right, because the plea is going to be to jail time, is that right? Okay, so it'd be at 1:30 at the, no, actually, I'm sorry, it'll need to be here.
Oh, really?
Yeah, because we're in the secure facility of the jail now, and so they're not gonna, they wouldn't let him come back there without being an inmate.
Gotcha.
So it'll be at 9 o'clock here, and then he'll go into custody here.
At 9 o'clock?
I'll tell you what, if you want to, let's do that at 11. You want to do that? Is that better? Let's do it at 11, and then he can go into custody over the lunch hour.
And that will be here.
That'll be here in the courtroom, yes.
Thank you.
You're welcome. You're free to go, Mr. Gardner. We'll see you back on November 9th at 11. Sanders, you ready? Who do you want to go on first, Meek or Wesley? Amethyst Wesley, CR 21-198. All right, so this one has the same thing on the judgment. It says Class A misdemeanor, but then it says SJF. So I'm just going to mark through.
It's SJF part. Yes. That's it. Here. It is technically a state code conviction.
Well, it says 1240. It says B though. So is it B or A?
It'd be 1244 B.
B. So it's going to be Class A misdemeanor conviction or Class A conviction and Class A punishment
Yes.
versus 1244A, which would be state jail conviction.
That's
Class
correct.
A.
I
Okay.
came to the wrong spot, yes.
Yeah.
So, yes.
All right, Ms. Wesley, if you'll raise your right hand. Ms. Wesley, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. Ms. Wesley, your name is, how do you pronounce your middle name? Lonese. So your name is Amethyst Lonese Wesley, is that correct? And Ms. Wesley, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss the case with him and have all your legal questions answered? Is there anything about this paperwork that you've read and signed today, Ms. Wesley, that you do not understand? And Mr. Sanders, do you believe Ms. Wesley to be competent today?
Yes, Your Honor.
And you've explained to her her legal rights?
Yes, Your Honor.
And you believe that she understands those?
Yeah, yes, Your Honor.
And Ms. Wesley, you've been charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. And the plea agreement in this case would reduce the potential punishment range to that of a Class A misdemeanor, which would be a maximum, if convicted and sentenced of a Class A misdemeanor, the maximum time could be 365 days in jail and a fine not to exceed $4,000. Do you understand that? Now I see that you've already reached a plea agreement with the state in which you'd plead guilty to this charge, and the state's going to recommend that your punishment be assessed at 2 days confinement in the county jail, with you receiving credit for 2 days of time already served. You would pay, you'd be ordered to pay a $3,500 fine in addition to court costs and a reimbursement fee of $535 in restitution of $180. Is that your understanding of the plea agreement? And you understand that you will be required to pay these amounts? And you understand that if you don't pay, that the court would issue a warrant for your arrest and put you back in jail? Okay. Understanding those things, Ms. Wesley, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram, a Class A misdemeanor? And are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty? All right, the court accepts the defendant's plea of guilt. Mr. Sanders, any objection to the state's evidence? State's evidence is admitted as Exhibit 1, and the court takes judicial notice of Ms. Wesley's judicial confession. Anything further from the state? From the defense? All right, court's reviewed the evidence, and I do find enough evidence to convict Ms. Wesley of this offense. The court will follow the plea agreement. Court convicts Ms. Wesley of possession of controlled substance, penalty group 1, less than 1 gram, under section 1244B of the Texas Penal Code. Court assesses her punishment at 2 days confinement in the Van Zandt County Jail. The court will award her credit of 2 days towards that sentence for time served. Court orders her to pay a $3,500 fine, court cost of $270, restitution of $180, and reimbursement fees of $535. All right, Ms. Wesley, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted. After you're fingerprinted, I want you to report down at the end of the hall to the court compliance officer to set up your payment plan to pay off some of these fines and court costs and reimbursement fees. Ready on Thomas Meek?
That is great.
Thomas Meek, CR 21228.
He's not here.
Oh, is he? Yeah, he's in Dallas County Jail. Is that right?
He's my check.
Do you want to go pick him up and bring him down here real quick so we can talk to him?
Yeah, I can sign him out.
I can reset him to 1:30 if you want to go pick him up. All right, so Mr. Meek, I'll have to reset him for pretrial. Are you available on December 14th?
Yeah, sure, that'd be fine. You know, I'll talk to the about this one. I'm not sure what you guys think down, Candy, but this one here, he was charged with then the rules, like he did with, so technically, it's technically, I think the state proceed here. It's not the different, but I think it's basically all the same.
Yeah, he's currently being held on a $100,000 bond for assault of a family or household member with previous convictions. Looks like 2 charges for that.
I think there might be a drug charge too, from what I can tell up their website.
All right, we'll set him for a status and pretrial on December 14th, and we'll see if he's made any movement on that case. Mr. Adams. Okay. We'll go ahead and take up your three. Which three are not, who is gonna be a plea? Fields? Fields and. Okay. Eric Ketchersid, CR 21223. To the podium there, sir. All right, and Mr. Ketchersid is set for docket call.
That's right, Your Honor. So I've received all the states, all discovery states filed. Have a pre-college state at this time, however, but the state and I have not had any session in our university. I haven't put it off in my materials. However, there's some issues that I'd like to discuss with the state prior to making announcements whether the results of the trial.
State any announcement. Can you look up to tell me if there is an offer?
I would be happy to.
Can you just tell me what the offer is?
I think here's TDCJ.
Any objection to his request for an additional docket call? You available on 12/14? All right, Mr. Ketcher said the court sets you for docket call on December 14th at 9 a.m. Once you sign and get to the yellow copy, you're free to go. Billy Schultz, 2020-513, CR 21-243. Mr. Schultz set for docket call.
Good morning, Your Honor. On behalf of Mr. Schultz, as President of Council. We have two cases on the docket to support. This is my announcement for Mr. Schultz's case is similar to my previous one. I have discovered in Mr. Schultz's case, I have not been finished reviewing all the materials I have not had any negotiations or discussion with the state's attorneys. So I would be asking for a reset, one more document. So that I can finish the discovery of the state and see which one Mr. Schultz and I are going to go next.
Mr. Woodwhack, any objection?
No, Your Honor. Eight years probated or 8 years.
All right, court will set Mr. Schultz for an additional docket call on December 14th at 9 a.m. Once you sign and get the yellow copy, you're free to go. Must be something like that. CR 21-247, Michael Sprouse? Which one is it? Is it Spruce or Sprouse? Sprouse. That's what I wanted to say, but I went against my gut. Mr. Sprouse is set for pretrial, Ms. Adams.
Yes, Your Honor, I don't have any pre-trial matters to take up right now. I will say that the state's discovery materials made available to us last Thursday. I haven't looked at those yet. Mr. Sprouse. So I would ask the court to set us for one more pre-trial. So review those things, visit the state of that.
Any objection? Court will set Mr. Sprouse for an additional pretrial on December 14th at 9 a.m. Once you get your yellow copy, you're free to go. You're welcome. You said that you've already reviewed discovery, or you're still reviewing?
I have not.
No. All right, so then we'll just wait on the paperwork and those. I was about to call you, but then you were stepping out, so I didn't know. So let me do this. Let me do this online, attorney, real quick. And then I thought maybe you're going out to speak.
Hey there.
Good morning, Mr. Howard. How are you, sir?
Hey, good morning. You got a busy day.
I do have a busy day. We're maybe halfway through. I'm trying to bring your client in, Ms. White. Let's see if
Yes.
she
Yeah, I see her name.
Yeah,
Just connecting to audio. Yeah.
just a second and see.
I'll text her and tell her we're on.
I think she's there. So I can prompt her to start her video with a little push of a button.
Oh, okay, there we go.
All we need is your video now.
Well, apologize. Start my video. Please select. Come on now. Sorry, I'm trying to see what.
Are you on your phone or your computer?
I'm on my computer.
All right, so Miss White, listen, I'm gonna send a button for you to push, okay? So don't touch anything. I'm gonna push a button right now, and it should say start video. If you'll just say okay to that, it should turn your camera on.
It said failed to start video camera. Please select another video camera in the settings.
Do you have a camera on your computer?
I do. Here, maybe I'll try to switch it to my cellular device.
Are you also logged into this hearing on your iPhone?
No, I'm on my computer, but I can log into on my phone real quick.
I tell you what, don't worry about it. Just stay with what you got, Miss White. We'll just go ahead and have the hearing with just your audio. This is cause number CR 2274 in 2021-324 State versus Carissa, Genevieve White, and we're set for pretrial today. Mr. Howard, do you have any contested pretrial motions in either of these cases?
Not at the moment, Your Honor. No.
Okay, so what the court would do then is find that there are no contested pretrial motions filed 7 days prior to the pretrial date. Court would then set Ms. White for a docket call date, and I would be looking at setting either in 2 weeks or on December 14th. Mr. Howard, if you want to look at your calendar and see which of those dates is preferable, then what I would be looking for from the parties is whether or not we're going to negotiate this to a plea agreement, or there's going to be a request for a bench trial or a jury trial between today's date and that date. So those are the 2 dates I got, November 9th or December 14th.
December 14th would be the best. And there's a number of documents, Your Honor, and I know that everybody's online, but that I'm going to be getting from Oregon, where she lives, from her doctors, and that I want to talk to the prosecutor with this. And I believe we're going to be able to settle this prior to that. But I certainly don't want to rush it so fast where we can't get everything he needs.
Okay. All right. So the court will set Ms. White then for docket call on December 14th at 9 a.m. and that will be an in-person hearing.
December 14th in person.
Yes, ma'am. At 9 a.m.
That works.
Okay. And I'll be in touch with the prosecutor between now and then.
Thank you, Mr. Howard. So Ms. White, this will be the only notice you get from the court. I'm not going to mail you anything or remind you. This will be the only notice that you get. Okay. December 14th at 9 a.m.
It's my birthday, so I'll remember.
All right. All right. We'll see you then.
Thank you, Your Honor.
You're welcome.
Okay.
Have a good day.
All right. Bye-bye. You too.
All right. All right, Ms. Beasley, you ready? Stephanie Rios, CR 21309. All right, Ms. Rios is set for arraignment.
I've gone over the arraignment. I've gone over the document. She's indicated that she understands person name. Her name is spelled correctly. She wishes to send her plea of not guilty this time.
All right, court will find that Ms. Rios has waived the formal requirements of arraignment. Court will enter her plea of not guilty into the record, and we'll set this for a pretrial hearing. Are you available on December 14th? December 14th. We could do it sooner, but it would only give you about 2 weeks.
Yes, Your Honor. I am judge, and if I can get it worked out sooner, I'll have about court.
Okay. All right, so we'll set December 14th at 9 a.m. So Ms. Rios will need to see the pretrial release department. So you're going to sign this form with Ms. Beasley, and it'll give you the date that you're coming back, December 14th. We're going to give you a copy of that. After that, come over here and meet with Officer Matura here to my right, and she's going to give you some additional paperwork and your conditions of pretrial release. Okay. Rachel, will you handle that for me? All right, we ready to discuss Ms. Fowler?
Yes, Your Honor.
This is CR 19-214, State versus Kimberly Fowler. Go ahead.
I believe we made agreement, probably this afternoon, we have a chance to go and custody. We already got the deal, and just have to be able to push off the plea for a little bit for her to get her on order. But she understands we accept the plea prior, we'll do this afternoon.
Okay, so is there so I don't officially have the results on the record of the drug test. Is there an agreement that between the parties that Ms. Fowler is in violation of her pretrial release conditions?
I think there's agreement that the test came back as a violation. We don't necessarily know that that's about the test, but we still want to enter a plea.
Okay. I just need to either get that testimony. If I'm going to order her into custody, I need to have a clear record of why I'm ordering her. So we'll just put on that testimony. Mr. Waddell, when you get a moment, I'd like to swear you in and get or was it Officer Matura that did the urinalysis test? Are you aware of Ms. Fowler? Yeah, I know she's busy. You've asked her if she'll just step out here for a second. What's the plea going to be to?
2 years.
Oh, yeah. You told me that. I just forgot.
Yeah, we are aware she's.
Officer Matura, if you'll come around here, I'm going to swear you in and ask you about Ms. Fowler's drug test. Will you raise your right hand? Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you go ahead and state your name for the record. And Officer Matura, you are a officer with the Van Zandt County Community Supervision and Corrections Department, are you not? And the court earlier this morning asked you to administer a urinalysis test to Ms. Kimberly Fowler. Can you tell me the results of that?
She is positive for prescription for, and then she's positive for methamphetamine on the instant test. She does not use, so it's going to be sent to the lab.
And did Ms. Fowler report any type of prescription medication that could possibly produce a positive methamphetamine? Any questions for Officer Matura, Ms. Beasley?
But my understanding, she did indicate to you that she stopped and surprised that it came back and positive for the drugs.
She normally
Mr. Woodwike, any questions? Okay, thank you. All right, the court will find that Ms. Kimberly Fowler is in violation of her community supervision correction, her probation conditions, and also a violation of the court's standard conditions of pretrial release associated with bail. The court will place Ms. Fowler in custody today and set her plea agreement set her to enter her plea agreement at 1:30. So bailiff, if you'll take Ms. Fowler into custody at this time. Give me an order on that. Yes, ma'am. Thank you. Go get some plea papers. Good morning, Mr. Todd.
How you doing, Your Honor?
I'm doing fine. How you doing, sir?
Doing well, sir.
Sorry, we were a little bit delayed. Big docket this morning. Mr. Keith,
Oh, no problem, Judge.
if you'll come forward, sir. Right there. Yeah, right there at that middle podium right there. Can you see Mr. Todd, your attorney on the computer there? All right. This is cause number CR 21-192, State versus Keith LaTroy Thomas, and we are set for pretrial today. Mr. Todd, do you have the discovery from the state in this case?
Judge, I do have the reports, and I had a meeting set up with Mr. Thomas, but I got called to trial out in Collin County this past week. So I wasn't able to meet with him. There is some media that we have sent some video, some DVDs down. I don't know if they've received them, they being the state, if they've received those and been able to send those back to me yet. When I talked with my legal assistant, she had just sent them out probably last week. So I don't know if they've gotten them yet.
Do you need additional time to review the discovery in the case with Mr. Thomas?
Yes, I do, Your Honor.
Any objection from the state?
Judge, we have no objection. I'm looking to see if those have been copied, resent out.
Mr. Woodwike, the assistant DA, said he's just checking the system to get the status on where the discovery production is. So he was going to report that.
Right. Well, we do have the reports that are in the portal.
Right. The DVDs have been copied. Your office has been notified. I'm unaware if they've been sent or arranged. They have been copied. They are available. I am unaware of whether they've been sent to Mr. Todd's office or whether they pick up or arrangements made. But they are available. If you contact my office, make those arrangements. However, that needs to happen. You're also one of those to reset so that that process can.
Did you hear that, Mr. Todd? I know my microphone.
I did, Your Honor.
Excellent. Okay. All right. So are you available on, I would be looking to reset you to either November 9th or December 14th. Those are the two.
I'm gonna flip over, Judge, and look at those
Sure.
2 dates.
Yes, sir. Please do.
And the second date you said was December 14th, Judge?
Yes, sir.
December 14th, I'm wide open on that day, Judge. On the first day, I have a lot of settings. So the 14th would be best.
Okay. Court will reset Mr. Thomas for an additional pretrial hearing on December 14th at 9 a.m. I'm going to have him fill out a notice of appearance and give him a copy with that date. And
Yes, sir.
So, Mr. Todd, you're free to go, and I appreciate you, sir.
Thank you, sir. And I appreciate you working with me, Judge.
Hey, you're very welcome.
Thank you.
All right, Mr. Thomas, Mr. Woodwike's going to bring this to you. If you'll just sign right here on this X right here, then we'll give you a yellow copy. and then you are good to go. Thanks, sir. All right, Cheryl Smith, she's an extension, she's a probation extension. Yeah, that's what I've got. I've got Cheryl Long Smith, my third one on the docket. This probation extension. I didn't see it here. Oh, yeah, I do. Here it is. Found it. Here it is. All right, we'll bring those two. Michael Welch, CR 18520. Good, I didn't know if you had seen my text message. I figured you were already on it. And I said, hey, will you handle that for me? I thought, well, she probably doesn't know what I'm talking about. All right, Mr. Welch, you are Michael Chase Welch, is that right? Mr. Welch, you've been charged by indictment with a third-degree felony offense of unlawful possession of a firearm by felon that carries a range of punishment of not less than 2 years or more than 10 years confinement in prison and a fine not to exceed $10,000. It's my understanding that you want to hire an attorney to represent you in this case.
Yes.
And you are currently on probation and pending a motion to adjudicate your guilt. You understand that? And so if I reset this case for a few weeks, do you feel like you'll be able to hire an attorney? So if I give you 2 weeks, do you think that's enough time? All right, the court will set Mr. Welch then for November 9th at 9 a.m. All right, so I'm going to fill out a form and have you sign it with your reset date. All right, Mr. Welch, I'm gonna have you sign here and then we're gonna give you a copy of it. We'll see you back on November 9th. Go ahead and check in with the probation department. Maybe they have some information for you. Mhm. Mhm. Thank you. Cheryl Smith. All right, this is cause number CR 18-414, State of Texas versus Cheryl Long Smith. This is an amendment to the conditions of community supervision. Ms. Smith, are you asking the court to extend your probationary period?
Yes, sir. I know that. Illnesses.
Do you believe if I extend your period for an additional year, which that would extend you out until November 7th of next year, do you believe that that would help you increase your opportunity to be successful on probation?
Yes.
All right. And has anyone pressured you to make you feel like you had to extend your probationary period? And this is something that you want to do?
Yes.
All right. Court's going to approve the amendment of your probation conditions and will extend you for an additional 1 year from November 8th of 2021 to November 7th of 2022. Court's also going to waive your probationary period, your probationary fees during that period, and also your analysis fees during that period. All right, so I've signed the amendment to the conditions of probation. If you want to gather your stuff and then meet with Officer Mature, we can get you a copy and you're free to go. Got two with Mr. Adams. I think that he's the only one left. All right, Ms. Furr. Ms. Furr. I'm sorry, Ms. Daly. I'm sorry. I was looking at the wrong thing. Ms. Daly, you'll step up. All right, this is in regards to the sanctions court hearing for Michelle Lynn Daly, CR 14-460. All right, I show that you did comply with your sanction to pay $120 to probation, correct?
Yes, I did pay my fee. $100 probation, or court cost like you guys would do. I paid my probation fee of $120 like you guys would do. I did not get to do all of my community service hours for this month. I do have proof that I have 3.5 for you. But Danielle, my probation officer, was having trouble being able to verify my hours for last month. So she told me that any hours that I do at the same place that I've been doing my hours since I signed the same court back in May, if I do them, they're not approved. Which I don't know what the situation is there, but since May, since I've been doing my community service hours at the same place since May, I have not had any problems until now. So I don't know if it's with Danielle or if it's with the community service, like I've been doing my hours. If there's internet or something, I don't know. But like I said, I do have my time sheet proof that I did 3.5 hours for that. I've been doing everything you asked me to do since May. I have not missed a payment. I have not missed a report date. I have been doing my hours. It's just the last month, Danielle was having a problem being able to verify that. And so she was having a problem. That did any hours that it is month. If she can't verify them, they're not going to be counted.
You don't have to. So Michelle, are we waiting to the very last minute to try to cram in 10 hours?
No, sir. It's not that I'm waiting until the last minute. I have my son. He is 13 years old. In fact, this lady here right here with me can verify that my son has football practice every day, Monday through Thursday. And I also take care of my 64-year-old son. So I'm trying to split my time between picking up my son from football practice, taking care of my mother, and doing my health. So it's hard for me. And at the place that I've been doing my hours, it's only 3 days that I can do them. It's on Tuesday, Thursday, and Saturday.
You know, that's not the only place that you can go to do your hours.
That's the only place that I'm approved to go to right now. I have to get Harrison County to find me somewhere else that I can be approved to do it. And I can do it more during the week than just on certain days.
Well, I think that's probably, the note I've got says that you can't work there anymore. I don't know. All I know is that can't be the only place that you can work. So you need to figure that out. And I understand having kids. I got kids too, and I'm going all different directions. But I know this, Michelle, if you don't do your community service hours, then you're not going to be there to pick up your son from football. You're not going to be there to take care of your mom. You understand that? Do you understand? I know. I understand. I'm not saying that you're not, but I'm saying you're not getting them done on time. You're not coming in here and having all of your hours turned into probation and them saying that you've done listen, okay? You're not getting them done in time and you're not getting them done the right way. That's the problem. You ever been on an airplane before? You ever been on an airplane? You know, when the stewardess comes in, flight attendant comes in and they talk about the oxygen mask falling. What do they tell you? When the oxygen masks fall, if there's a child next to you, what are you supposed to do first? Are you supposed to put the oxygen on the kid first or on you first?
I'm gonna put it on myself first.
Why?
Because if I can't take myself, I'm gonna be able to take somebody else.
So how are you going to take care of your son and your mom if you don't take care of this first? This is taking care of you. I understand that. You might have to call on somebody to help you take care of your son and pick him up and get him here and there. You might have to call on somebody to help you. Might have to call another parent. I do that. I can't be 4 places at once. I have to rely on my friends and my family and other people to help me. I do that. And I don't have to work community service hours. I do community service hours. I do. I volunteer. I want to do those things. But I have to make it a priority, and that's what you're going to have to do. You have to make it a priority. So I don't want to hear excuses. I want you to go out and do what you're supposed to do and get this stuff done, because I'm tired of seeing you every month, and I'm making you come back every month so that I can make sure that you're doing what you're supposed to do. Because Michelle, there's no sense in you going to prison over this.
No, I don't want to go. I don't want to go.
All right, then let's work harder. And let's get it done. There's no reason you can't do 10 hours a month of probation.
Right.
There's no reason.
I think what it is, I honestly don't think it's not that I'm not turning them in. It's not. It's hard for Danielle to be able to get a hold of the place that I've been doing them since May to verify. And that's why I can't get credit for them, because she can't verify. But if I'm finding the sheet at the place that I've been doing them, I'm faxing her my time sheet. I'm not understanding how she has to verify like 3 or 4 times.
I don't know. I just know if that's a problem, I would fix it. If that's a problem every month, I would fix it. I would go somewhere else that's easy to contact where your hours can be verified. I'm just telling you, that's what I would do to fix it. All right. So I'm going to have you come back on December 14th. And I want you to do, so you're 7 hours behind now, right? You did 6.5 hours. So you owe me that plus you owe 10 hours plus 6.5. That's 16.5 hours. Okay.
And 120 for probation and 100, is it 50 or 100?
It's 50. It's 120 to probation. It's 50 to collections to the court for your fees.
In 16.5 hours.
And every month it's 10. And so every month you don't do 10, your next month gets bigger.
Yes, sir.
And the reason we set it at that is because that's what you have to do every month in order to complete your probation and avoid going to prison. That's why we're doing this song and dance.
Thank you very much. Thank you.
All right, Michelle, sign this form. We're gonna give you a copy and we'll see you back on December 14th. Mr. Adams, are you ready? Are you ready on? You're welcome. Rebecca Fields, CR 2118. All right, do we have paperwork? No. That's it. All right, Ms. Fields, if you'll raise your right hand. Ms. Fields, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got. All right, you may put your hand down. Your name is Rebecca Fields, is that right? Ms. Fields, you're charged by indictment with a state jail felony offense of abandoning or endangering a child with criminal negligence. And if you were convicted of that offense, you could be sentenced anywhere between a minimum 6 months and a maximum 2 years in a state jail prison. Do you understand that? You could also be ordered to pay a fine up to $10,000. Do you understand that? Are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss the case with him and have all your legal questions answered? Do you understand everything that you've read and signed today? Mr. Adams, do you believe Ms. Fields to be competent? And you've explained to her her legal rights and also the advantages and disadvantages of a deferred adjudication plea? And you believe she understands those? All right, Ms. Fields, I see here that the agreement that you want to enter into is that you would plead guilty to that charge for abandoning or endangering a child with criminal negligence. And the state would recommend that the finding of guilt be deferred. That means that you not be convicted today, but rather you be placed on 2 years community supervision with fine, court costs, and reimbursement fees. Is that what you want the court to approve? And you understand that if I approve this, I place you on community supervision, that if you violate any of the terms and conditions of your probation, at a later time, the court could conduct a hearing and could, upon finding that you violated, could revoke your community supervision, could convict you of this offense, and could assess your punishment anywhere between 6 months and 2 years in state jail prison without parole. Understanding those things, you still want to go forward? How do you plead to abandoning or endangering a child with criminal negligence? And are you pleading guilty because you're guilty of committing that crime? Say again. And has anyone threatened, forced, or pressured you to plead guilty to this offense? Mr. Adams, any objection to State's Exhibit 1? State's Exhibit 1 is admitted and the court takes judicial notice of Ms. Fields' judicial confession. Is there anything further from the state?
Yes, Your Honor. Just wanted to make a brief ETS update again. Field is, I've been told, going above and beyond services. It's well on track to get those children back. So we want to keep an eye on her for the next couple of years, make sure everything stays stable. The effort, I believe, she'll put in the effort.
Thank you, Ms. Heisel. Anything further from the defense? Ms. Fields, is all that true? What Ms. Heisel said? That's what I want to hear. That's good news for the court to hear, that you're doing your services and that you're working hard at trying to get your children back. And so I expect you to work just as hard on this probation so that you can avoid prison and be there for your kids. You understand? All right, the court, upon reviewing the evidence, finds that there is sufficient evidence to convict Ms. Fields. However, the court will follow the plea agreement in the case. Court defers the finding of guilt places Ms. Fields on 2 years community supervision, orders her to pay a $1,000 fine, $290 court cost, $590 reimbursement fees. Ms. Fields, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with my bailiff. After that time, report over here to Officer Matura and she'll give you further instructions on your probation. All right. Do you have anything this afternoon?
I did, I have Mr. Foster up in the court center, so I could reply to you.
Okay. We're gonna recess at 12. So if she contacts you, then just tell her to report here at 1:30. And then after you do your jail stuff, if you want to come over, then we can do the plea here. Do you have the paperwork already? Oh, it's not a plea this afternoon? Oh, no, I'm McMillan. I was talking about McMillan. Yeah, she can come here and do her plea at 1:30. Okay. Do we have any update on Mr. Ashmore? Mr. Ashmore? They're all Mr. Ashmore.
Flash showed up late, so we had to have paperwork sent over to here. Last week, we're getting to this, I believe that was his last sitting, so we're working hard to try to get that done. That was kind of unexpected.
Is she? Okay. Mr. Ashmore, are you ready?
We're ready. All right, we're waiting on some restitution calculation on Mr. Dobbins. Judge, this is Ron Lazarus and Chief of their office. Doing a ride along today, so right, she comes up here.
Absolutely.
Thank you, Your Honor.
Good morning. Nice to meet you. All right, so you're waiting on Dobbins. You're waiting on Dobbins. You ready?
Yeah, he's in the hall. We just got one restitution issue to work out with Stephanie at the DA's office. Once that document gets sent over, she'll send it in. But I'm ready on everyone else.
All right, Laura Fleming, CR 21261. Right there at that podium right there. Just step in front. There you go. Yes, ma'am. All right, this is cause number CR 21261, State versus Laura Joy Fleming, set for pretrial. Any contested pretrial?
No, and we don't anticipate there will be any, Judge. There is an offer. It's 14-month state jail. We did just get it today. We'd like some time to visit with our client about it and ask for a reset.
Are you available on December 14th? And while he's looking at that, Ms. Fleming, after you sign the notice of appearance today, I need you to report to the pretrial release department. You're going to be assigned conditions of pretrial release that are attached to your bond in the case. So you're going to be required to report, pay, drug tests, things of that nature. Okay. So after you sign the notice of setting, we'll give you the yellow copy, then you can report through the store.
Okay, Judge. 12/14.
All right, 12/14 at 9 a.m. Is Jason Nichols here?
Jason is here.
All All right, CR 2187, State versus Jason Eric Nichols, set for docket call.
Yes, Judge, we've been negotiating at length over this matter with the state. Jason, my client, is an honorably discharged United States Marine veteran of the war in Iraq and Afghanistan, combat veteran. We're asking for an additional pretrial, or excuse me, an additional docket call to try to coordinate with Brendan Rivera-Jones, the Veterans Court Coordinator, who oversees the entire program. I've already called Mr. Quentin Avenatti, who's one of the veteran volunteers who coordinates veteran intake. He believes that Mr. Nichols would be a candidate. We're asking the court for a docket call so I can work those possibilities for a deferred offer, which the state does support, but supports more thoroughly, an opportunity for him to get some services through the Veterans Court program.
All right, so give me, I'm not familiar with the Veterans Court and what services and resources you're talking about. Can you explain that to me?
Yes.
What it is you're trying to do for him?
Yes, Judge. So Veterans Court was started about, I believe, 10 or 12 years ago in Dallas County only by Mr. Joe Lynch, who's a friend of mine, and some other attorneys and judges coming together to try to find a way to get young veterans who are coming back from the wars on terror.
No, I mean, I understand the concept. I'm saying, what is it that you're seeking to get him into that's going to affect the case here?
He would need to fill out a Veterans Court application. They would need to approve him. It's a assault family violence case, and even though there is alcohol involved, it's not an alcohol and drug related case because it is an ISP diversion program for drugs and alcohol and all the things that we know that young men and women we send over to fight our wars are coming back home with these demons.
Sure.
So
No,
that's essentially, we need to make sure that he can, one, get the application. We don't have it yet.
So you're looking to enroll him in a program that's going to offer some kind of services and resources that you're using as leverage to convince the state to give you some type of offer. It's nothing that's going to be a condition of probation here or a program that we're administering, right?
No, it would be administered, Judge, if he were accepted. So application's about 16 pages long. He has to go do an intake in.
All right, so
Kaufman County.
you're asking to have the case reset so that you can try to get him into that program so you can relay that to the state.
Exactly.
Any objection?
No.
Okay. All right, then the court, do you know, is December 14th going to be sufficient enough time?
We need 2 Veterans Courts. The Veterans Court meets one Friday per week in the 5 counties that it goes to. So I should have two opportunities to show up in Kaufman and present his application to Ms. Jones, the Veterans Court Coordinator, Mr. Avenatti.
Okay.
So at 12/14 would be great.
All right, court will set Mr. Nichols for a final docket call on December 14th. Clarence Rowan. This is CR 2360 set for pretrial.
Yes, Judge. Mr. Rowan just recently got a deferred offer, 12 months, $1,000 fine, 24 hours. Community super. And we would like to take that offer. Restitution's already been paid in this matter. We just can't get the paperwork done today, Your Honor. We're gonna ask court to reset it, 12/14 works, and come back and do the plea on the 14th.
All right, court will set Mr. Rowan then for December 14th to enter his plea. Mr. Rowan, you do need to report to pretrial release, and you're going to be assigned conditions of pretrial release in this interim period until your case is resolved. In addition to that, Mr. Rowan, I believe you were arrested out of county, correct? All right. Okay, but you weren't arrested in Van Zandt County. So the state collects arrest information and the sheriff's office does not have your arrest information that they need. So I'm going to have you take this processing order. I'm gonna order you to report out to the Van Zandt County Sheriff's Office after you leave court. What this is gonna do is gonna tell them to take you in there, fingerprint you so they can get the information they need, and then you're good to go. It's just, we need to process your fingerprints because we don't have those from where you were arrested. Okay? So you're not gonna be booked in, you're not gonna be required to change out and stuff like that. They're gonna take you to the back, they're gonna book you in, book you out, and send you on your way. But you'll need to take this order with you so they'll know who you are and what I need them to do for you. Okay? All right. Will you get Mr. Rowan a copy of that? They'll need to see you for pretrial release conditions. I've already told you. So. All right, Mr. Dobbins, if you'll come forward. This is CR 2158, State of Texas versus Randy Lee Dobbins. Mr. Dobbins, if you'll raise your right hand. Mr. Dobbins, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. Mr. Dobbins, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him and have all your questions answered? Is there anything about this paperwork that you have read and signed today that you do not understand? You understand everything? Mr. Ashmore, do you believe your client to be competent today?
I do, Your Honor.
And have you explained to him his legal rights?
I have, Your Honor.
Do you believe he understands those?
Yes, sir.
Is this a deferred?
It is deferred.
And have you explained to him the advantages and disadvantages of a deferred adjudication plea?
Yes, sir. Talk about deferred on successful completion of dismissal, returning him to the situation that he has enjoyed his whole life, which is all citizenship rights. And also at the risk of, violations of the sanctions, so that probation condition package, but also means that the punishment range is posed that the punishment range, if there were to be sanctions on probation.
All right. So, Mr. Dobbins, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram, but less than 4 grams. That is a third-degree felony. It does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. If I approve this plea agreement today and place you on deferred community supervision, and if you subsequently violate any of the terms of your probation, after a hearing and evidence, the court could revoke your community supervision, convict you of this offense, and sentence you to prison anywhere between that 2-year to 10-year range. You understand that? Understanding those things, you still want to go forward? All right, court, we'll ask you at this time, Mr. Dobbins, then how do you plead to the third-degree felony offense of possession of a controlled substance? Are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? Court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to states 1?
No, Your Honor.
States 1 is admitted. Court takes judicial notice of the defendant's judicial confession. And I see that there's enhancement paragraphs in the indictment, but are those being abandoned at this time?
Yes, Your Honor. Mr. Dobbins has a twin brother that has some convictions that appear on his criminal history. Through Mr. Ashmore, Mr. Dobbins has proven to the state judiciary that those were not his convictions, even though they appear on his criminal history, so we are abandoning those.
Just so we're clear, Judge, Mr. Dobbins, this is the good twin brother. This is his first offense. He admitted that the illegal substance was his at the stop. He's admitting that the illegal substance is here before this court. Like not wasting the state's time, and the state's agreed to abandon those enhancement paragraphs.
Just in case that ever makes it to TDC, we just mark through that, put states abandoned or wrong defendant. Just in case if he does violate and goes to TDC, they don't look at that and consider that some kind of aggravating factor. Thank you, ma'am. All right, court's going to review the evidence briefly. All right, court's reviewed the evidence. I do find sufficient evidence to convict Mr. Dobbins. Court will follow the plea agreement in this case. However, court will defer a finding of guilt, place Mr. Dobbins on 4 years community supervision for the 3rd-degree felony offense of possession of controlled substance. Penalty group 1, greater than or equal to 1 gram, less than 4 grams. Court assesses a $3,500 fine, $180 restitution, $290 court cost, and orders Mr. Dobbins to pay reimbursement fees of $785. Mr. Dobbins, you're hereby remanded to the custody of the Van Zandt County Sheriff's, or I'm sorry, to the Van Zandt County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the bailiff. After that time, report to Officer Matura over here. The only one that I don't show called and answered is Caleb Richardson. So, but Mr. Manning, Mr. Manning's not here to make an announcement. Mr. Richardson must not be here. Okay. All right, so I'll have this name. Will you call the name Caleb Richardson? Okay, but was I taking that under advisement? Did I say under advisement for a certain period? No response. All right, the court has called the name Caleb Richardson, had it called loudly, distinctly in the courthouse 3 times with no response. Court hereby finds that Mr. Richardson is on a personal bond. The court will find his personal bond to be insufficient and will set new bond in the amount of $40,000. All right, we are adjourned until 1:30.